Hello everyone. Do you hear me? Do you see me? You can text message in our group chat if all is good.
I
Thank you
see
very much.
familiar faces. Yeah.
So we can start. My name is Vita. I'm business development manager at CompTivisor. Today I'm joined by Tigran, founder and CEO of Incubator. Hi Tigran.
Hello.
Today we will talk about the Canadian MSB when it actually works and when it fails because of strategy, not regulation. A quick clarification from the start. This is not a webinar about how to open a Canadian MSB quickly or easily. Canada itself is really the problem. In many cases, a Canadian MSB can be a solid starting point for international operations. Most issues appear later because of how the framework is used, not because of the jurisdiction itself. Today we'll share practical observation from real cases, what works, what doesn't work, and why some MSBs fail after registration. Before we start, it's important to highlight that the content provided today should not be deemed legal advice. We will be sharing information based on our experiences, and therefore it can be different based on the size and complexity of your organization. Please feel free to reach out us after the webinar if you are looking for tailored feedback relative to your individual situation. So let's start with the basics. In Canada, an MSB is not a product and not a license. It's a legal classification based on what your business actually does. This classification comes from the Proceeds of Crime and Terrorist Financing Act, Canada's main AML law. In simple terms, it defines who is considered an MSB and what obligations apply. A company qualifies as an MSB if it performs certain activities on a commercial basis, such as currency exchange, money transfers, issuing or redeeming payment instruments, and certain virtual asset activities if they fall under FINTRAC rules. FINTRAC is Canada's AML supervisory authority, and this is critical. FINTRAC does not issue licenses. MSB registration does not mean guaranteed banking, approved business model, or permissions to operate. Registration means something else. It means your business enters an ongoing AML regime. Compliance applies continuously, not only at the start. So the key takeaway is simple. An MSB is not something you get and forget. It's a regulatory status that stays with the business as long as it operates. Now, a few words about FinTrack. FinTrack does not approve business models. It does not give permissions to operate. Its role is supervisory. FinTrack is less interested in what is written on paper, and much more interested in how ML works in practice. One of the most common problems is the gap between documents and reality. The gap usually doesn't appear immediately. It shows up later during reviews, information requests, or banking discussions. This brings us to scope. On paper, the MSB framework looks broad. Many founders think, if I fit the definition, I'm fine. In practice, it's not enough. Two companies can offer the same service but still be treated very differently. These boundaries are rarely written in one rule. They appear through supervision and banking feedback. So being formally in scope does not automatically mean the model is safe, scalable, or bankable. And now let's talk about baseline expectation. This is not about best practices, and it's not about having a perfect ML setup. Baseline expectations mean one thing. Your compliance must be good enough for your real business. If your model is simple, expectations are lower. If your model is complex, expectations rise very quickly. Regulators and banks are not comparing you to an ideal company. They are comparing your setup to your actual risks. So baseline expectations are the minimum level at which your is considered credible. Below that level, issues are not a question of if, but when. And now we are moving to the next block, Canada as regulatory anchor and strategic fit in 2026. Tigran, let's start with a strategic perspective. Why do founders continue to look at Canada as a regulatory anchor in 2026?
Thank you for the question. Vita, Canada is still considered to be the launchpad for fintech. We do have a stable economy, relatively, we can say that. We also have the tech talent and regulatory clarity, and it has been for a very long time. Uh, Canada is still considered to be a jurisdiction that is really friendly and reputable worldwide. Majority of the fintech founders choose Canada to be the launchpad for their headquarters to start their fintech business for several reasons. One of them is very practical. Canadian money services businesses allows to open bank accounts outside of Canada. Many money services businesses in Canada, they don't have Canadian clients. So they still choose the Canadian money services businesses to start their process to test their MVP to begin with, and then they go global. Aside from that, Canada is one of those unique jurisdictions where it can actually offer you easy entrances to bigger jurisdictions. For example, USA. Okay, a lot of founders do choose Canada because of the close proximity to U.S. borders. As you know, Canada, 70%, I do believe, Canadians live like 30 kilometers far from U.S. border, and it's very easy for you to have that access. These are some of the main reasons why Canada is considered to be the anchor. Aside from that, I can also add that we do have regulatory clarity, okay, streamlined processes. So you do know what you need to actually do to get your fintech getting going and being operational really quick. Unlike any other jurisdictions, you do have a lot of hoops that you need to go through, and timing is an issue. Here, it's very streamlined, and it can actually allow you to get going with your MVP really quick.
Thank you, Tigran. Canada
Mhm.
is often described as stable and predictable from a regulatory standpoint, but stability can also mean rigidity. How would you describe the balance between regulatory stability and operational flexibility within the Canadian MSB framework?
When you have a money services business and you are authorized to conduct that business, it does not mean that that's it. Okay, you need to meet your obligations and liabilities that you have with the regulator. Many times we do see that it's a stable economy, stable regulator, stable everything as a jurisdiction, but many businesses fail just because they don't pay enough attention on their liabilities that they currently have with the regulator. Now, look into it this way, okay? Many businesses in Canada simply fail because they don't really see and or foresee their operational reality with what they're allowed and what they're not allowed to do. For example, client comes in, says, "Hey, I want an MSB. I'm going to do this." And then when they get the authorization to conduct the activity, they realize that their operations are not compatible with what they have applied for. And many times they actually fail. Okay. Many people don't know, but there are many regulators in Canada, not just FINTRAC, as you have mentioned. Sometimes you would be triggering obligation with other regulators that you need to actually register with. So when we are talking about the regulatory stability and operational rigidity, I can say that you cannot really oversee both of them without paying enough attention to both of them effectively. So you need to make sure that what you do operationally aligns with what you're allowed to do regulatory from the regulator's point of view, if that makes sense.
Thank you. From your experience, what types of business models are structure aligned the Canadian MSB framework?
Good question. Yes, any typical fintech is really suitable if you're operating money transmissions outside or inside of Canada. From two foreign exchange dealers are big. Virtual dealers of virtual assets, meaning you can operate OTC desks, allow someone to buy and sell virtual assets, uh, subject to limitations, of course. Foreign exchange dealing, money transferring, crowdfunding platforms are really popular. You could process transactions as well. Payment service providers are MSBs as well, and many more. But these are the four most typical ones that many founders would apply for, which is foreign exchange dealing, dealing with virtual currencies, a money transmitter activity, and PSP, payment service providers.
And on the another side of that, what are the typical examples of business models that formally fit within the MSB definition, but start creating downstream risk once real operations begin?
So that's a good question. So look into it this way. Let's assume you have registered as a PSP. Okay, the biggest risk is that right now you're triggering also obligation to register with Bank of Canada under the Retail Payments Activities Act. Many founders just don't really realize that there is another regulator that they need to apply for. Okay, so that's one. Second thing is when we talk about crypto is really massive. So an example would be where you are registered to deal with virtual currencies, but people don't know that not every virtual currency you're allowed to offer. Okay, because you would be triggering regulatory obligations with Ontario Securities Commission, Alberta Securities Commission, BCFSA here in British Columbia, where I'm located, and so on. So you need to pay attention on all of the aspects as a whole. Okay, so you cannot really emphasize just one regulator and conduct that activity. You need to constantly evaluate if you're triggering other regulatory obligations within Canada. So in the scope of money services businesses itself, he provides you the basics for you to start and to add, certain activities, test the product, go global, and then after you have done that, yes, you need to add more resources towards compliance and get proper registrations and authorization. An example would be for you, we had a client a couple of years ago, started with money services business, went everything okay, they tested it, they looked into it, they set up the processes, banking relationship and everything, and boom, right now they're ready. They're registering with Ontario Securities Commission, okay, and offering things like custody, allowing clients to do some other activities. For example, they were thinking already doing lending, derivatives, and so on. So all of this is part of it.
Okay. And I have one more question. At what point does registration stop being the key milestone and continuous compliance becomes a real operational challenge? When does the focus shift from we are registered to we must define this model on an ongoing basis?
When you scale, so technically, when you scale, everything would start. Okay, we have clients that have 10,000 end users. 10,000 end users is a good amount for you to test your MVP, to do everything that you need to do. But we have client that has 500,000 clients. Okay, so this is when it becomes an operational hassle. You need to add compliance team members. You need to make sure that all your reporting is in place and properly done. You need to pay more attention. So scale is what matters. Okay.
That makes sense. Thank you, Tigran. And our next topic is licensing and setup. A few words about corporate structure, control, and substance expectations. Corporate structure is about control. Control means three things: who accepts the clients, who executes the transaction, and who stops the activity. If those decisions are made outside the registered company, the structure is artificial. If a company calls itself a service provider but directs flows or touches funds, it carries operational risk. Substance means operational involvement. The company must actually control its activity. If the real decision center sits in another jurisdiction or with a third party, the model is structurally weak. The structure must explain how the business behaves. If it cannot, it is a structural defect. And what about management, governance, and operational footprint considerations? Management means real decision making, not names on a registration form. Governance means a clear decision chain, defined accountability, authority to stop transactions. If key decisions are outsourced or made informally, governance does not exist. Operational footprint is where the business actually runs. Onboarding, monitoring, approvals, inside and handling. If operations sit outside the declared structure, credibility drops immediately. Registration fixes three elements. The first one, who runs the activity. The second, how decisions are made. And the third, where the operation lives. If that does not match reality, the risk is embedded from day one. So, Tigran, when FINTRAC reviews an MSB registration, and what is it really evaluating beyond the form?
Beyond the form. So it's like technically substance over the paperwork, I would even say. What you have written down and what you currently really have, that's what they look into. I can confirm that you are constantly being evaluated by the regulator. Okay, it's not one time thing. You need to be constantly ready. You have sent your registration in, you have told them that you have been conducting money transmitting and PSP activity, but then you suddenly do virtual currency. That's not okay. You have to advise the regulator immediately, or actually within 30 days, once you have a change of your model. If you don't, you would be charged, you would be dinged with administrative monetary penalties, and we have seen that in the past. So, ideally, it's always to be ready for it, and ideally, the program has to align what you have told the regulator that you are doing. Okay, paperwork doesn't really matter. If you have said that you're doing ABCD, you gotta be doing ABCD. Okay, if you said that you're doing ABCD, but you're doing EFG, that's not okay. The
Okay.
regulator can come in and say your program does not align with your written compliance program. Okay, so you were telling us that you're doing transaction monitoring, but you're not doing transaction monitoring. Explain why. Okay, so this is not okay. So you have to make sure that what you have told the regulator it aligns with your program.
Exactly. But in practice, what typically triggers FINTRAC examinations?
Oh, say it again. What
Typically triggers FINTRAC examinations? Is it
triggers? Yes,
growth in volume, changes in the business model, reporting patterns of banking signals, and also what is the usual timing? How long after launch do companies typically face supervisory attention?
can happen a week after you've registered. Can happen 10 years after. You have to always be audit ready. Okay, so that's how it works. What does really triggers the audit? I don't want to consequently say specifically what it does, but I would say the following: it is a combination of many factors. Volume can be one of them. Amount of suspicious transaction reports that were filed that you were mentioned there would be one of them. Could be a adverse media. Okay, can be whistleblower situation where someone complained about your business. Can be just you were a number there and they decided to do just in case. Okay, and many other factors. But the bottleneck is that at this point of time, if you're operating in money services business and you have registered yesterday, today you have operation, you have to be ready for audit at any moment. It can happen today, it can happen 10 years from now.
Yeah, thank you. And I have one more question about interrupt the difference between off-site and on-site examinations. How should companies interrupt it?
It's like the same thing. It's just outed, guys. Okay, so one of them you're drinking coffee with Vita. Me and Vita are drinking coffee online. One of them is drinking coffee at the cafe, face to face. It's a regulatory examination. Okay, both needs to be treated seriously. Both needs to be prepared properly. Both needs to be cooperated with the regulator at the highest level possible. Okay, so you need to cooperate when you do undergo through a FINTRAC examination. So make sure that you do. If you don't, it would be much more worse. Always cooperate. If they find a mistake, it's good. So you know your mistake that you have missed. That's okay. There are always mechanisms where you can actually fix your program. Okay? It's not something, hey, I need to circumvent this audit by any cost. No. For example, at the email incubator, we welcome the regulator to come in and audit our programs because we want to know what we're doing wrong. Okay, so and I'm really happy whenever that happens. I'm actually excited because it's an attestation of our work. So client comes in, we they expect them to help. They expect us to help them, and when we do, the FINTRAC comes in and asks questions about regulatory examination. We're very happy because we go through our work with them to see if we've missed anything. Yet if we did, there's always mechanisms for you to deal with it and fix that. Okay.
Understood.
Yeah.
Tigran, based on real examinations, what are the most common findings you see? I mean, which red flags tend to repeat across different MSBs?
Great question. So there are 5 things that you require to meet your obligations with FINTRAC specifically. It's a competent compliance officer, written compliance program, risk assessment, training, and an effectiveness review every 2 years after you've conducted your first transaction. Okay? Guess what? Takes 1 day to checkmark one of them. Training. Okay? So you just need to make sure that you and your team sit once per year and do a training. I have seen it's so common for companies to fail the training because they have not properly documented who attended that training. Okay, very fun fact, but it's true. It's one of the most common ways for you to fail it. Second most common things that I have seen in the past, based on my experience, is where your written compliance program and risk assessment does not align with your business model. Okay, so an example could be you have written down a written compliance program, your AML ATF policy suite, onboarding, offboarding, transaction monitoring, life cycle of suspicious transaction report, PEP screening, this and that. And you have all this beautifully done policy suite alongside with the risk assessment, but they're nothing to do with your business. Nothing to do with your business. So what happens is a lot of money services businesses just take a template from somewhere and they say, okay, let's change the name there on the top and let's adopt it. That's not how it works, guys. You need a proper risk assessment. You need to properly identify money laundering and terrorist financing risks associated with your business. You need to properly articulate that into your written compliance program with up-to-date minimum at least once per year, ideally once every like 5 to 6 months, because things change. For example, you've changed your vendor for your onboarding. Takes a minute. Go update your written compliance program. Say there that, hey, effective today, instead of us using a third-party verification tool like A, we're using X now. Okay, all of these are very important things. So these are the most common ones that I've seen. I've also seen lately, which is very important. It's publicly available information. An MSB was charged with administrative monetary penalty because they have not properly advised the FINTRAC for change of information. Okay, guys, takes like literally 1 minute. It's a form online. Go tell FINTRAC that you've changed your address. Okay, it's very important. Change the activity. Okay. Another one that I need to be very explicit, which is more serious administrative monetary penalties. You need to make sure that your record keeping is in place, and you need to keep it 5 to 7 years. Okay, so if you have KYC'd someone, Okay, why beat someone when you entered into a business relationship? Make sure that you keep these records. Cannot really lose them. Keep them in a safe place. If you lose them and you do not provide this to FINTRAC during audit or FINTRAC examination, they would say that you don't have proper record keeping in place. And the last one is suspicious transaction reports, which is very important that I need to actually explicitly advise. Suspicious transaction reports need to be properly written down and properly reported to the regulator on time. As per the guidance received by FINTRAC, the timeline is as soon as practicable. Okay, so but it's not the end of it. So you found a suspicious transaction report and you reached to reasonable grounds to suspect that an activity is related to money laundering or terrorist financing. You report them. That's not enough. You need to properly articulate your rationale behind why you have reached out to reasonable ground to suspect from simple suspicion. I've seen so many businesses where FinTrack says, okay, you have identified the suspicious transaction report, but like you just said, hey, this report is being filed because it's suspicious and we're filing it. No, that's not okay. You need to put in actionable intelligence. You need to put the story, proper narratives in to make sure that FINTRAC can actually use this report in the court of law. If you said, hey, we feel this is suspicious and that's why we're reporting it, this is not okay. You need to articulate properly as why you think so, what happened, where happened, who did it, why they did it, and so on. Okay? So these are some of the common ones that I wanted to share. I think there are more, but this is enough, I think, for today. Yeah.
Right. Thank you for the answer. And when sorry, when adverse findings appear, how do they affect to business beyond the examination itself? What typically happens to operations or banking relationships or counterparty?
Depends on what the outcome of the audit was. If you were charged with administrative monetary penalty, the banking relationship might be affected. Okay, banking partners might reach out and ask you, "Hey, you were just charged administrative monetary penalty. Show us how have you been remediating it, and whether you agree or disagree with what you have charged." Okay, so it will affect your reputation. It is very dangerous. Okay, a lot of the businesses that were charged administrative monetary penalties, it was actually end of their business. Okay, so FinTrack believes that you are not compliant. Okay, any other banking relationship that you have, having you as a business using their infrastructure is risking being non-compliant as well. So you have to make sure that you pay enough attention. But it is not the end of the day. If FinTrack found deficiencies with your program, simply take reasonable measures to fix them. Show this to your banking partners. Show this to your banking relationship that you have and your vendors. And this is very normal. Okay. There are businesses that constantly do have deficiencies. I do believe there is no businesses without deficiencies. Okay. There is always some. Make sure you fix them if they were found. And then it also depends how severe these deficiencies are. Okay. If you have willfully circumvented all the regulations, reporting obligations, and you have done everything to make sure that you are not compliant, you'll probably have a problem. Okay. But if you have done reasonable measures, you have tried to make sure to put enough efforts to fix your program since the beginning of the operations, should be fine. Okay. There's always okay to have deficiencies. It's normal. Just make sure you fix them. Cooperate with the regulator. Advise them that you have deficiency. A lot of people don't know, but there is this thing called voluntary self-declaration of non-compliance with FINTRAC. You can tell them, hey, FINTRAC, I found a deficiency. I want you to know about it. I need to take A, B, C, D, E, F, G steps to fix them. This is how much time I need to do it. I need you to be aware in case you audit me. I'm letting you know on time. So in case you audit me, you don't really come to a surprise that we have this deficiency. And FINTRAC would come back and say, okay, thank you very much. Let us know when you remediate. Okay, and tell us how you did it. Does it make sense?
Of course.
Yeah.
And finally, beyond formal penalties or fines, what regulatory consequences tend to follow?
Regulatory consequences tend to follow.
Yeah.
Revocation of your MSB registration is one of them. Okay, you can simply lose your ability to effectively conduct the activity. Is one of them. Your MSB can be seized. Okay, criminal penalties might come in. Criminal charges might come in. So up to 5 years of imprisonment. Okay, so you, Vita, and me, Tigran, who runs an MSB, for example, can go to jail together. Okay, so we need to be very careful.
Thank you, Tigran. And now we are already at our block 5. It's banking and operational pressure points.
Sure.
And the first topic is why MSB registration does not guarantee banking access. One of the most persistent assumptions around Canadian MSB is that registration somehow unlocks banking. Not automatically, not formally, but at least in practice. This expectation usually breaks very quickly. From a bank's point of view, MSB registration answers only one question: is a business inside a regulated ML perimeter? It doesn't not answer the questions that matter most to the bank itself. How predictable are transactions? How clearly defined is risk? How much uncertainty sits inside the model? Banks are not relying on FINTRAC to do risk selection for them. They carry their own regulatory exposure, their own supervisors, and their own tolerance thresholds. And MSB may be fully registered and still fall well outside what a particular bank is willing to support. Another important point is timing. Registration happens before the business has operational history. Banking decisions are made when real transactions, real clients, and real patterns start to appear. At this stage, the bank is not looking at the registration status anymore. It is looking at behavior. This is why registration does not function as a gateway to banking. And Tigran, once an MSB is onboarded, what do banks start resisting? What changes between the initial approval stage and the moment real transaction flows begin?
That's a great question. So at the beginning, they evaluate your policy suite, risk assessment, volumes, ownership, framework that you currently have. When you get going, they actually evaluate your behavior, whether what you have provided to them aligns with your behavior. For example, you've told them, hey, I'm not doing anything with the sanctioned jurisdiction of North Korea. And then suddenly Kim Jong un sends you wire transfer to buy some weapons from you in Canada. That is not okay. All right. So you don't do that. So you need to make sure what you have provided to them aligns with what you do. And they would be evaluating. So in Canada, continuous monitoring of business relationship is a big thing. Guess what? Banks do that. So you should do as well. Okay. So during this monitoring, they will evaluate whether what you have provided to them aligns with what you really do. Easy.
And what do banks expect to see in ongoing transaction monitoring?
They expect you to have it and it has to be effective and working. For example, if you have transaction monitoring, you say, oh, I look at the transaction monitoring every day. Okay, but based on what? What are the rules of your transaction monitoring? Do you look into velocity, frequency of the transaction, volumes of the transaction? Do you compare them with the current onboarding or ascertaining data that you currently have for the client? Does it align? For example, lawyer brings in $1 million. Okay, it's a lawyer. They have $1 million. Probably it's okay. But then a student brings in $1 million. You got to evaluate where the source of funds are coming from, right? So these are all questions that are always being asked. Your transaction monitoring is a massive component of your program. Proper transaction monitoring with proper tools would always mitigate and deter money laundering and terrorist financing. This is how you actually find the suspicious activity on your platform. Okay, you just need to make sure that your transaction monitoring aligns with your business. So at the beginning, it's very simple. Just watch what's coming in, what's going out, and how you follow the funds. Money came in, money went out. Okay, it came from where and where did it go? Then you look into the frequency and velocity of the transaction, then the volumes of the transaction. Then you compare everything with the documents that you currently have on the end user or the business that you have on board. Make sure that aligns. It's not that overly complicated. It gets complicated where you have millions of transactions per day. Okay, when you are actually processing volumes, massive volumes, $1 billion per month. This is where actually it gets complicated, and you need proper tools and proper strategy for your transaction monitoring. And the banks would always look into it. And the reason why is because they have their own transaction monitoring. So they look into it as well. And you need to work with them as well, saying, hey, what are you guys looking for us to look into? Cooperate with your banking partners to the extent that they would allow.
Right. And how does misalignment between ML design, actual operations, and transaction geography typically surface? And where does this gap become visible first, to banks or to regulators?
Both banks, both regulators would actually see it because banks would have obligation to report to the regulator, and the regulator will see that you are operating in jurisdictions where you're not supposed to, and Canadian jurisdiction is not okay with. One of the most common thing is sanctions violations. So you're not supposed to deal with uh, individuals or companies that are under sanctions in certain jurisdictions. Okay, so and it would resurface when you conduct that activity. It's not overly complex, it's very simple to identify. The reason that you identify, you look into the individual behind of the transaction, and then you see, for example, that individual is from the jurisdiction of Iran. By the way, nothing against Iran. I love Iranians. We have a massive diaspora here in Canada. But you're not allowed, and it's under the ministerial directives to conduct certain activities with certain companies and people from the jurisdiction of Iran. Okay, and it would resurface right away because you're Iranian, for example, and you write down the wire transfer or money transfer. I'm sending this money to this individual, and it would pop up with the banks, and banks would ask further questions.
Thank you, Tigran. And now we move to the interesting part where MSBs fail.
Oh,
And Tigran, we often see companies that look fully compliant on paper. At what point does paper compliance become visible as a structural weakness? What signals show that compliance exists as documentation but not as control?
again, it has to align with what you really do, right? If you have a program that you've written down, it's beautiful, but you're not implementing anything from that program that you wrote, it would resurface at some point with banks, regulators, and your vendors that you use your services with. Okay, so for example, you have mentioned in your program that it's not under your risk tolerance to service certain business segments, but suddenly you do. And banks and regulators would actually ask questions as to why you're doing it because it's not aligned with your risk appetite as per your policy suit. Okay, that's one. Another way for you to fail is not paying enough attention that you have obligations with the regulators. Many founders, they don't like to deal with compliance. They say, okay, we got the authorization. They always call it a license. We have an MSB license. We're good to go. No, getting an authorization with FINTRAC, for example, It's like 10% of the work. Okay, you need to make sure that you meet your obligations with the regulator. You need to make sure that you have proper policy suite that aligns with your operations. You need to make sure you have proper ways to ascertain the identity of the business relationship that you're engaging with. You need to make sure that you report the transactions that are reportable to the regulator. You need to make sure that the staff is properly trained. You need to make sure that everyone follows the rules. If you don't do all of this together at the same time, it would get you into trouble and your money services business would fail. Not just because regulator would ask you to seize your MSB or shut it down, but because you would simply lose your banking access and you will not be able to operate. Not just in Canada, but outside of Canada as well. I need to emphasize, okay, getting an MSB is not even 10%, it's like 5% of the work. Running it properly, compliantly, is the rest of it. You need to pay enough attention to make sure that you stay operational. I've seen so many MSBs come in, try, then miserably fail, just because they have not put enough resources and or enough attention on the compliance aspect of it, or meeting their obligation with the regulator.
Yeah, and when transaction flows start drifting away from their original logic, at what point does inconsistency become a supervisor issue rather than operational flexibility?
Sorry, can you repeat the question? I think I missed it.
Of course. When transaction flows start drifting away from their original logic, at what point does inconsistency become a supervisor issue rather than operational flexibility?
Whenever they actually deviate from what they were originally were supposed to do. An example could be you're registered to conduct a money transmitting activity alongside with PSP, but then suddenly you have the opportunity to do a lot of cryptocurrencies and you start operating an OTC desk with your business. Then you put in crowdfunding platform. Suddenly you accept cash. We were not supposed to. And then you are not letting anyone know about what you're doing. We had an instance here in Canada where suddenly the client started doing check cashing, but no one knew about it. Neither the compliance department did. Hey, what is this transactions? We raise, and they go, oh, we're doing check cashing. Okay, when did we start doing this? And then they say, okay, we did it like a month ago. And then we raise a concern, hey, we're not allowed to do this, right? We need to make sure that we advise the regulator. We need to make sure that we update our risk assessment. We need to make sure that we update our policy suite saying that we're allowed to do this. We need to advise our banking relationship that we currently have that we're in process of doing this activity and so on. So when you deviate from a regional business model and you start doing things that you initially did not intend to, this is where it becomes a problem.
Yeah. And can you explain us why do some regulatory questions only surface after launch? What changes between how the model is described at registration and how it's assessed once real activity begins?
It's very simple, Vita. To be quite honest, majority of the time, you deviate from the original plan always. So you have started one activity, but you cannot really conduct that activity because a lot of bottlenecks come in during that time. And these questions would be raised once you get operational. FINTRAC and other regulators, they expect you to deviate from the original plan. That's okay. The idea is to properly advise them on time that you are doing so. Okay, so deviation is okay as far as you properly advise the regulator that you would be deviating from your original plan.
Thank you, Tigran. And our final block is who should and shouldn't choose a Canadian MSB. And the first topic, it's a question for Tigran. What is the ideal business profile for a Canadian MSB?
Anyone that is trying to again test their MVP, ready to go global, needs the tech talent, Once a jurisdiction with a reputable regulator, okay, straightforward, very straightforward processes in place, are ideal for anyone that is going to get into the fintech as a whole. You want to do crowdfunding platform, we're the best place to be. We have the tech talent, we have the infrastructure, we have the global reputation. Anyone that is going to operate a money transmitter business, payment service provider, foreign exchange dealers worldwide, conducting an activity typical to dealing in virtual assets, helping clients buy and sell Bitcoin, Ethereum, okay, operating, this is a big one too, operating money transmitter based on stable coins. This is big as well right now. Okay. I don't want to get into RWAs or other complicated products right now, but they also are good to come to Canada and talk about here in Canada as well, because whatever you're building and what Canada can offer would support your infrastructure. That's the final bottleneck. That's the final idea of Canada. Whatever you're building and it's related to fintech, you need a Canadian money services business because it will support your infrastructure in one or other way.
How about early warning signals? What are early warning signals that choosing an MSB is a strategic mistake?
When you're not ready to meet your regulatory obligation, when you are like into business, when you're coming from a jurisdiction where you operated before without any regulatory oversight, don't come to Canada. You would fail. Okay? Don't be
Okay.
pushy. Yeah, don't like I want this done today. No, that's not how it works here. And another thing I want to mention: do not negotiate prices with compliance service providers here in Canada. Okay, for example, at Daymel Incubator, we offer services for building a program for helping clients to register their money services businesses. We help with remediation. We help with training. We assist them to get banking access here in Canada. But the moment people start saying, okay, you give us a price, I want this price. This is not how it works in Canada. Okay, it's okay for many jurisdictions that doesn't really work in Canada. Don't do that. Like for example, I have instances where clients come in and start negotiating the price with me for the services that we would be offering. We say, hey, listen, no, 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 don't do that, okay? We are making prices affordable and accessible for Canadians for a reason, and this is accessible and affordable already. If you cannot really maintain this, Canada is not the right path for you, okay? Because we need you to invest substantially more into compliance in the future. If you're not ready to do that, this is not the right place. Okay, don't come to Canada. But again, I will mention Canada is the jurisdiction that is accessible, affordable. As you know, for Canadian money services businesses, there is no required capital to have. Okay, so regulator does not expect you to actually put in capital. They might change it soon, but right now there is none. So if you want to come to Canada, it's easy and straightforward and it's affordable and accessible for you to do so. But if you're coming with the notion that, hey, this is the cheapest way for me to do it, don't do that. That's not right. It's not cheap. You are expected to invest in the proper infrastructure for your compliance. If you don't do it, you would fail.
Yeah, you're right. Tigran, thank you so much. And to wrap this up, it's important to fix one simple idea. A Canadian MSB is not a universal answer. It is not inherently good or bad. It works in very specific conditions. It works when the business model fits the framework, when rules are clear, and when limits are accepted upfront. It starts creating pressure when it is used as a flexible wrapper for activities it was never designed to support. If after this conversation the main question you are left with is a Canadian MSB actually right for us? This is a healthy outcome. The next step is not rushing into registration. It is stepping back and comparing your real business to the framework, your role in transactions, how value moves, where your clients are, what infrastructure you depend on, and how you plan to grow. From our side, when we work with cases like this, we usually do not start with registration either. We start by stress testing the business model against the MSB framework. Sometimes the conclusion is that MSB fits. Sometimes it is that another setup makes more sense. Both outcomes are fine as long as they happen before the business is live. With that, we will close the main part of the webinar and move to questions. If you recognize your situations or any of the patterns we discussed today, or if you are unsure how your model would be read in practice, this is a right moment to ask us. 1 second, I will read the questions.
Are there any?
So, yep, we have question from Tommy. We got more than 6K MSBs. How we can check which ones are active?
I have no idea what the question. Can I read them? Tommy, we got more than 6K MSBs. How we can check which ones are active? You can't actually, unless you just probably, with the data that you currently have, reach out to them and ask whether they are active or not. Honestly speaking, it is more than 6K, I do believe, on the list in the public ledger that you can find. Yeah, that's pretty much it. Best way for you to do your own due diligence by looking whether they have website, trying to contact them. That's pretty much how it works. If you're asking whether you will be able to do that from the public sources or from FINTRAC, there is no other way that I am aware of.
So, yeah, we have another question. 1 second. Are there any requirements from the regulator that the client monies must be held within Canada?
Great question. Retail Payments Activities Act. Yes, there are. Segregation of funds, proper risk, enterprise-wide risk assessment needs to be implemented. If you're keeping client funds, you need to keep it in the proper way. Okay, so it's very important for you to follow these rules, and you would be triggering regulatory obligation with the Bank of Canada. Kindly read these obligations under the Retail Payments Activities Act, or reach out to us. We will help you out with it. Okay, so just reach out to me or Vita. We'll give you some details and presentations and proper resources for you to undergo through it.
Thank you, Tigran. And another question, what are the main risks for an MNRO who agrees to a fractional role in MSB with a foreign owner who is not a Canadian resident?
He's not a Canadian resident,
Yeah,
so you just
owner is not a Canadian resident.
Oh, okay. Like any other risks that you would have, okay, this is something very important that we need to talk about, okay? So, five things that I've mentioned during our webinar today. One of them is a competent compliance officer. That competent compliance officer does not have to be physically in Canada, okay? That person can be outside of Canada, but so can be the ultimate beneficiary owner of the business. Okay, so if you are acting as a content compliance officer for a business outside of Canada, you would be facing the rest of the risks associated with the business. For example, fraud. And what's the right word? 10 sec. I'll find that word for you. I always forget. It's any situation where you would be involved in as an indemnifying party with fraud, any sort of a illegal activity like scam, any situation where your business would be creating a harm. Willful blindness is another one where you need to make sure that you properly follow. If you see something illegal, you have to advise the regulator. You, as a money laundering reporting officer or chief anti-money laundering officer that we say in Canada, have to make sure that in any situation where you're the acting camel for the business, you do not break the law or let that company break the law. Okay, so if the ultimate beneficiary owner of the business does involve the business into activity that is not okay in the eyes of not only regulators but under the Canadian law or criminal law, okay, you're not to actually engage with that client. You're not to engage with the business, and you need to advise the regulator. And you, as a camel, might face consequences in the eye of the regulator, including but not limited to an individual that indirectly or directly participated in an illegal activity. Simple words.
Thank you, Tigran. And we have one more question. Does an MSB have any limitations on its operations? Can it run
Of
a
course.
business like an MEI PSP we know from Europe? Oh, sorry. And is an MSB a good choice for neobank focused on B2B?
Can I read that question? I'm so sorry. It's from Tommy. Yes, is
Yeah,
that the
from
question?
Tommy.
Does an MSB have any limitation on its operations? Can it run a business like EMI PSP, we know from Europe? And is an MSB a good choice for a neobank focused on B2B? Okay, so yes, it has limitations. Yes, you can actually run like a EMI, a PSP from the Europe. And for neobank, is it a good choice? Yes, but I have so many things that I need to tell you about it because there are so many other factors. What you just have asked, that we need an hour of consultation. Please book a consultation. It's free. Come in and I'll explain how everything works. I will not be able to explain this on this call right now, but the short answer is yes. Okay, but there are so many other factors, and you need to be there to properly structure and conduct that activity.
Yeah. And for now, we don't have questions anymore. So
Don't, because
yeah,
I just wrote from the previous question was very important. See, this is part of the contract that we currently have at the email incubator that we share with our clients. It's a clause. I want you to see that clause. So it's you as a camel might be very much a liable if you allow fraud or willful misconduct. Either party in indemnification obligation expressly set forth in the agreement breaches the confidentiality obligation, and so on. Things like that that you need to be aware of. You cannot really allow that. If that happens, you as a camel, you might be actually liable for all of that activity that was conducted. Okay, so you need to be very careful.
thank you, Tigran. Thank you so much for the conversation. And we didn't manage to go through the crypto part probably today, but don't worry, it's all covered in the guide you will receive after the webinar. Thank you for joining us and have a nice evening. Tigran.
Okay. Yeah, thank you. Thank you so much. Thank you, Vita. I appreciate it. It was a pleasure talking to you as always. Thanks for organizing all of this. And yeah, reach out to us or Comply Advisor if you have any questions, and we can support both of our organizations, small competitors to each other, but we work together in tandem. So let us know if you have any questions or you need any assistance. Love you all. Bye bye.
Bye bye.